Welcome everyone to this new episode of the Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia. I'm officer at Privacy Rules. The Privacy Espresso is a concise, effective, to-the-point advice from data privacy and cybersecurity experts worldwide. And today we have one of them with us, that is Chiara Agostini, partner at RP Legal and Tax in Italy.
Perfect.
And Chiara is a data privacy expert, focusing among others in the advertising sector. And today we are going to discuss about a topic that is related to that is the difference between loyalty programs and marketing activities. So Chiara, hello and welcome with us today.
Thank you. Welcome to you too and everybody that are in audience.
Perfect. Thank you. And let's start warming up. So I would like immediately to ask you, speaking about the legal basis and the distinction between loyalty program and the legal basis for marketing activity. Is there any difference under GDPR or they are the same?
Yes, there is a difference. Before starting a data processing, particularly, any data controller needs to find the correct legal basis for its processing that has to be regulated under Article 6 of the GDPR, and which needs to be lawful in respect to the specific finality of the data processing. Data collected, moreover, in respect to the principle of data minimization, shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are collected. Having said that, when a data subject enters into a loyalty program or a privacy contest or the more innovative cashback initiative, in respect of whether the cards or the request of participation are issued free of charge or not, the promoter has to process his data in order to fulfill its obligation in favor of the subscriber, as better described in the terms and conditions of the promotion itself. We can say that the processing is necessary for the performance of the contract to which the data subject is a party under Article C, letter B of the GDPR. Data collected, moreover, shall be the only ones that are relevant and limited to what is necessary to let consumers enter in the promotional initiative, as for example, their identification data, their contact details, or the overall amount of their expenditure in respect to the promoter, of course. On this point, I don't think that it could be correct processing profiling data, such as, for example, profiling based on the analysis of the consumption habits or choices, or on another perspective, health data that, in my opinion, seems not to be adequate for this specific finality. On the other hand, a processing for marketing purposes or statistical evaluations cannot be based on the fulfillment of an obligation by the data controller. That is because this specific processing is a discretionary and optional one, and as such, the data collection shall be based only on the consent of the data subject under Article 6, letter A of the GDPR. The legal basis of this data processing, the one for the loyalty program and the other one related to marketing purpose, in conclusion, are different. The privacy policy that the promoter shall serve to the data subject needs to explain this difference, and the consent form needs to be drafted in compliance with this setting, and also taking into account the possible necessity to require a further and autonomous consent to process data for profiling marketing purposes.
Okay, perfect. Thank you very much, Chiara. And speaking about this, and since you and your law firm is in Italy, is there any decision from the Italian DPA on this matter or anything going on there?
Yeah. Yes, there is. The Italian Data Protection Authority emitted various measures on this matter, Example are the guideline applying on loyalty programs issued by the Italian DPA in February 2005, and the very recent decision adopted in 2019 and 2020 against, on one hand, Media World or for a loyalty program, or other two decisions against the Pamper loyalty program, the GS loyalty program. In these decisions, the Italian Data Protection Authority provided also very heavy administrative sanctions against the promoter in their capacity of data controller. All said measures particularly banned the use of data collected for the participation of promotional initiative for the sending of advertising and promotional contents to fidelity card holders or participants who had not previously expressed their consent for the processing of their data for marketing purposes. Particularly, the DPA stated that a single privacy consent required by the promoter in order to let the consumer join the program and for marketing purposes is not valid, essentially for two reasons. The first one is that this approach is not correct to enter into a program in which the right legal basis is the fulfillment of an obligation. And the second reason is that in general, it's not lawful asking one consent for two different purposes, as it is not possible to assume in this case that the consent is freely given by data subject. The Italian DPA, moreover, stated that for the participation in a loyalty program, the data controllers had collected data which were irrelevant and excessive in relation to the purposes of the loyalty program itself. The DPA therefore warned said data controllers to no longer use for marketing purposes or statistical evaluations the personal data collected through the form of fidelity card, and it also imposed to modify the privacy policy and the relative consent form in order to ask a specific and an autonomous consent for marketing purposes and, if it's the case, of course, statistical evaluations.
Okay, perfect, Chiara. That's really interesting. Thank you very much. And speaking about these, which are the key takeaways for a data controller in particular?
The key points of this privacy espresso can be the following. First of all, the importance to draft a correct privacy policy in order to build a lawful database that can be used in the future by the data controller. Second, clearly split the legal basis for different finalities, and particularly clearly indicate that for fidelity program, the legal basis is the fulfillment of an obligation, while for marketing activities, the legal basis is the consent of data subject. Lastly, I would like to highlight the importance of a correct consent form drafted in full compliance with the content of privacy policy.
Perfect, Chiara. Thank you very much. And we ran out of our time, at least for this introduction in the topic. So thank you very much for being with us today. And also thanks to all our listeners of today for joining us. I would like to invite you all to join our next Espresso next week on Thursday 28th at 10 a.m. because we will be speaking with a guest speaker from Hong Kong. So it's in the morning European time. And I'd also like to invite you to contact Chiara for any need and to follow the Privacy Rules LinkedIn and Twitter accounts, and also us at www.privacyrules.com. And I hope to see you all again next week. And I thank you again very much. Bye, everyone.
Bye, and thank you for your attention.